Good afternoon and welcome. My name is Jim Spencer. I'm the Director of Development and Plan Giving at the college. I'm joined by my colleague, Pam Persichetti, who works in our Alumni Engagement Office. When we're on campus working, we work in Green Hall. We're proud to present today's session on wills and common mistakes to avoid. And we're going to turn our program over to one of our own. Steve Kornas is an associate at the law firm of Hanlon, Neiman, and Wright. It's in Freehold, New Jersey. Steve is a member of the class of 2012 from TCNJ. He was also a campus EMS member and also involved in student government. And he earned his JD from Rutgers University School of Law in Camden. And Steve's expertise is in estate planning and how to help his clients plan best for the future. So if you have any questions, you can please utilize the chat feature and we'll be going through and Pam will be working on that. So thank you once again for joining us and I'm going to turn it over to Steve.
Thank you very much, Spence, and hope everybody is well today. And Pam, if you can pull up the presentation for everybody, please, I would appreciate it. Like Spence had just mentioned, I am Stephen Kornas. I was a senior senator of science. Next slide, for me, Pam. Actually, go back for 1 second. I'm sorry. This is my contact information. We'll be able to. I'm sure we'll be able to provide it to you in case you have, further questions. But certainly, if you'd like to get in contact with me, that's the best way. So next slide for me, please, Pam. All right. So as Spencer was outlining for all of you, I started in the College of New Jersey in August of 2008. I was a senior senator of science. I graduated with a Bachelor of Science in Biology with a minor in political science. And I was always into public policy and and the law, and actually found my passion for the law when I went to a class in the College of New Jersey. I took legal challenges in healthcare with Professor Sparacio, and she was the one that actually inspired me to go to law school. She was a nurse and a lawyer. She did family law, and I remember my first day in class. I was answering a bunch of questions about the Constitution, and Professor Sparacio pulled me to the side and said to me, Stephen, you should really think about going to law school. And at the time, I wanted to keep all my options open. I didn't know what I was going to do, and I said, well, I'll think about it. And then, sure enough, 2 years later, she was writing my first recommendation letter to me for law school, along with Professor Rossi from the political science department. Unfortunately, I don't think he's still with the college, but nonetheless, TCNJ has had a big effect on me, and I'm always passionate to get back to the alumni community. From there, I went down south to Rutgers in Camden, and I graduated with my Juris Doctorate in 2015. Like in the College of New Jersey, I joined up with the Student Bar Association, which is student government for law schools, and became the parliamentarian. I actually was the parliamentarian at TCNJ when I was in student government there as well. So I always had a passion for rules and procedure and all. And then I also became a senior editor, actually, at the Rutgers Journal of Law and Public Policy. And I've been with my firm since 2015, and officially got my license in December of, or I should say sworn in as an attorney in New Jersey, December of 2015. So that's my official start date as a licensee. So next slide for me, please, Pam. So if I can leave you with nothing else today, it's that there are two definites in life. There And I'll leave you with a quote from Benjamin Franklin, and saying that there's only two things that are definite: death and taxes. Now, I can help you with the first part. The second part, I'm going to actually discuss a little bit today in terms of death taxes when the two areas collide, if you will. But generally, when it comes to income taxes and all, that's where you get a CPA to help you. So, but I can help you with the first part. And one of the reasons why I wanted to do this is because there's so many people that are out there that don't have the estate in place. They don't know what's going to happen to them if something does, God forbid, happen to them. If, let's say, the person becomes incapacitated, if the person, if the family needs to know what that family member's last wishes are. If you've ever come across that type of situation, I know it's always, it's always a difficult conversation to have, but it's a conversation that I help clients out with on a regular basis. Because at the end of the day, the last thing you want for a family member is for him or her to go into a hospital, basically become incapacitated, and then after that, have to worry about, what was Aunt Susie's last wishes, or what would Mom wanted us to do? Would she want us to, pull the plug on her? Would she want us to keep her alive with whatever means necessary? And also, too, it's not just about healthcare decisions, which are always the toughest thing. If Mom needs to to pay for a facility, if Mom needs to pay for a lawyer to represent her, it's not like you have automatic access to Mom and Dad's bank accounts, to Mom and Dad's IRAs, and to Mom and Dad's other assets, if you will. You want to make sure that you're able to get in touch with them, with these banks and with these institutions, and have the necessary documentation in place in order for you to be able to do so. So I'm going to talk a little bit about all of that today. And we call that whole process, because I don't deal with just death. I deal with pre-death as well. I deal with those types of situations where somebody becomes incapacitated. But the main focus and the big push for today is estate planning. Now, as you see on the screen, estate planning is the process of trying to work out a person's assets to make sure that they go into the correct beneficiary's hands, while at the same time being able to minimize any types of taxes that are applicable to the situation, income taxes. And I think we just lost the presentation, but income taxes and generation skipping taxes and what have you. You know what? Give me 1 second. I'm going to just move my thing over. There we go. And I'm going to pull this up there. Okay, great. All right, so I can see my screen. Okay, so when I say an estate, what do I mean? Basically, anything that has your name on it is part of your estate. So for example, I list a few things there: your car, your house, if you have an investment property, your bank account, certificates of deposit, IRAs, 401k, furniture, life insurance policies. Okay, if your name is on it and it's something that is tangible, like this desk, or is a back or has your name on it, and you can put assets in like a bank account, it's part of your property, and it's something that ultimately needs to be disposed of when you pass away, because you can't take your assets on with you to the next life, if you believe in that. You have to make sure that your physical assets, what you have earned here, on this planet, is able to go to whomever you want it to go to. So next slide for me, please. Okay, so one of the ways to ensure that your estate goes into the hands of whom you want it to go to is through a document called a will. A last will and testament is the official name. And the will basically designates for people whom your assets go to. Now, your will can be as simple as upon my death, everything goes to the person, everything goes to my children. It could be as simple as that. For those of you that are Parks and Recreation fans and remember the scene with Ron Swanson, who said that upon my death, everything shall pass to the man or animal who kills me. A very rudimentary type of will, and something that would be difficult in probating, but that is nonetheless a will. So it could be as simple as that. It could be as complicated as wills that we prepare that put in specific provisions about where I want XYZ property to go to, or where I want who I want to get my car, or who I want to get my jewelry. And you can put in provisions in there, and we'll talk about this too, in terms of putting certain assets for kids into a minor's trust, which is something that you would put into a will, and you would define the terms of the trust in there. And you would also, in the will, you would also designate, who's going to be the one that is the legal representative of the estate, whether it's an executor, if there's a trust that is created within the will, who the trustee of the trust is. If you have minor children, you can appoint a guardian in the will. Now, keep in mind that even though you make that appointment for a guardian, that you have to make sure that ultimately the court is going to sign off on that. A guardianship process, and I don't want to get too far into the weeds in this because that's not what today's about, but a guardianship process involves putting on notice basically every potential person that could be the guardian for a minor child, and the court basically ascertaining the fitness of the person that you want appointed as a guardian. Now, you can make a recommendation, and the court will take that recommendation to heart. Pam, if you could go back, thank you. But ultimately, the court ultimately has final say on who the guardian is going to be. If the court doesn't feel that the person that you designated in your will to be the guardian is fit, then they will recommend somebody else. So keep that in the back of your mind. It is something that's good, and something that at least people. It's going back to the issue of telling people what you want if something should happen to you. But ultimately, it's something that isn't binding on the courts. Now, if you don't have a will, okay, and you pass away, then there are default laws within the state of New Jersey that decide how to distribute your assets to your beneficiaries. Okay, so basically, in the state of New Jersey, if your estate contains any assets that need to be passed along, and you don't have a will, then the way it would work is you would have a spouse or a child or a parent or a brother or one of their children, and so on and so forth. Basically, ask the court, the surrogate court in this case, to appoint a legal representative to be in charge of the estate. Excuse me. And the surrogate would have them apply for a bond and for the value of the estate. And then once you become the appointed administrator of the estate, then those assets will go to whomever your next of kin are. So for example, if mom and dad pass away, neither has a will, and let's say mom has passed away and then dad dies, and both of them had 3 children, okay, one of the 3 children can become the appointed administrator of the estate. They'll have to get the consent of their two siblings in order for them to do so. But once they do so, then they would become the administrator of the estate. They would manage the estate's affairs, and then ultimately they will be able to pass along the remains of the estate to themselves and the two other siblings. Okay, and one of the issues that people run into, and one of the reasons why you want to do a will is, a lot of times everybody tries to have a close family, but unfortunately there are plenty of times where brothers and sisters don't get along with each other. And a lot of times, one of the things I like to call my estate administrations, because I do help folks that have had a loved one pass away and help them administer the estate. A lot of times what I have to deal with are brothers and sisters that don't get along with each other. And I call estate administrations family divorces in some respect. And the reason for that is because a lot of times brothers and sisters that see a pot of money that mom and dad left for them and want to do something with it. And let's say there's some personal possessions that are involved, that one wants, let's say, mom's diamond engagement ring, and another sibling wants the diamond engagement ring. Well, both of them can't get that diamond engagement ring. Just giving a hypothetical in this situation. It's always a tough, thing to deal with, because then you have to basically figure out a compromise between the siblings. Unfortunately, I had a very sad estate administration case where we had siblings fighting over mom's jewelry and what should happen with mom's jewelry when you pass away, or when she passed away, excuse me. And it ended up in litigation. We had to work out a compromise, between the siblings as to who would get mom's jewelry at the end of the day. So a will helps to avoid that, those types of issues. And a will is something that also takes the burden off of your children, your parents, grandparents, etc., to make sure that the estate is being administered properly, and ultimately you can direct who gets the property in your estate. Next slide for me, please, Pam. So I've gone through this a little bit, but I gave you a basic list here of when a will is important. The number one reason why you should get a will, for nothing else, is if you own a house. If you own a house, or if you own a condo, or if you own a piece of real estate, you need to have a will in place, because at the end of the day, that real estate, unlike bank accounts, unlike IRAs where you can designate a beneficiary, or you can designate whom you want to get your property, real estate is limited in that sense. Now, there are certain types of ownership. So for example, if husband and wife own a property together, and one of them passes away, then the widow becomes the owner of the property. Now, if that person also then passes away, there's nobody on the deed. And then at that point, that piece of property becomes part of the estate that needs to be administered. So if you don't want, let's say you have a house and you want it to go to kid A and kid B, but you don't want it to go to kid C, then you need to put a will into place to say that you want the property upon the death of husband and wife to go to kid A and kid B. Because if you don't, and you pass away and you don't have a will, well, now kid C has an interest in that piece of property. So very important, if you have a piece of property, a piece of real estate, to make sure that you have a will in place to be able to control the disposition of that property. Bank accounts are another reason why. Now, a lot of people, you might be thinking to yourself, if let's say you have a bank account and you own it with your husband or wife, and you say to yourself, well, if one of us passes, the other will get it. Well, and that's what I want done with my bank account. So in that case, if something does happen and one of you does pass away, you're absolutely right. Okay. And, you can have that property go to, go to go to your other spouse. So certainly, you want to, that's a situation where a will wouldn't be something that would control that disposition. However, when going back to the example that I gave before with real estate, you would have to, when both of you pass away, you would either have to designate either a beneficiary on that bank account, or you would have to, make sure that, that bank account goes into your will and goes into your estate, and then your will would control the disposition of the bank account. So another reason why you would want you would want a will in place. You have property you cannot designate a beneficiary for. That goes again back to real estate. Sometimes, let's say, for whatever reason, going back to the husband-wife example, child A dies a couple months after both husband and wife pass away. Well, in that situation, child A would still be entitled to the inheritance, again, assuming that the will is in place that basically says that you are allowed to give that piece of property to child A, but it would go into child A's estate, and child A's will, would control that disposition of property. So that's another example of property you can't designate a beneficiary for. A big one is item number 4, a business. Okay, if let's say you own a small business, if you have shares in a business, if you own stock in a business, and you don't have a shareholder agreement in place, if you don't have a minority interest in place, you want to make sure that that your business is going to the right people. Okay, your will would ultimately be in control of that. Now, with that said, a lot of times business partners will prepare a shareholder agreement, or if it's an LLC, a membership agreement that will control what happens when one person dies, and it would control how that person's interest is bought out, who would get the proceeds if it goes into the estate. So it depends on, so ultimately you want to look, when you're thinking about estate planning and you own one of these types of interests, you have to look towards your shareholder agreement, your business membership agreement, in order to ascertain what ultimately happens with that person's interest, because that will trump whatever will is in place. But certainly, if you don't have that in place, then your will would be in control. And so, unfortunately, in this case, if something does happen, then you want to make sure that your will is, properly states who gets your shares in the business. I talked a little bit about item number 5 a lot. If let's say you want to disinherit child C because he or she said something to you or wronged you in some sort of way, that's a reason why you need to do a will, because otherwise, in the example I gave before, where a husband and wife don't want child C to get the interest in the property, if there is no will, then child C would get an interest in the property. So another reason why you want to do a will. Another reason too is if let's say you want somebody outside of your family to get your estate. If let's say you want to leave everything to your best friend Tony down the street, or even too, if you wanted to bypass your children. I'm dealing with an estate right now where the decedent had a will that basically said everything goes to his beloved niece. Okay, and and he had children, but he specifically said, I disinherit all of my children. So if you want that type of situation, if you want your property, if you want all your possessions to go to your favorite niece, favorite nephew, or somebody that outside of the family, then you need to do a will for that purpose. If you have minor children, okay, and something I alluded to earlier, if you have minor children in place, you don't want them to, if something does, God forbid, happen to you, you don't want them to come into a position where you've got your kids that are, let's say, 15 or 16 years old, coming into hundreds of thousands of dollars and having to be saddled with the responsibility of dealing with that property outright. So, because a lot, I remember even a lot of times too, I have clients that, for kids that are college age and going to TCNJ or whatever college, they still don't want their kids to be able to get the money or the real estate. They want everything to go into trust, for the children. In that case, because the state of New Jersey says that everything would go outright to your children if both husband and wife pass away, then or partner and partner, whatever type of marital relationship you have, then you would want to make sure that everything that would otherwise go to your children goes into trust for your children, and have that trust controlled by a trustee, whether it's the children's uncle, whether it's the neighbor down the street, to become the trustee of the trust. I unfortunately had a situation like this where I had a couple that had just divorced, and the husband or the ex-husband in this case passed away, and in this situation, the wife, the ex-wife said, told me that there was no will and that everything would therefore pass to her son, their son, and he was under the age of 18. Now, we were able to ask the court's permission to put everything into a trust on his behalf, but it cost a lot of time, it cost a lot of fees, and it taxed the trust and the estate in a way that you wouldn't have had to do that if you just had a will in place to basically say upon my passing, if I should have a beneficiary that is under 21, everything shall go into trust for him or her to be controlled by X, Y, and Z person. So that's another reason why you want to have that. And then going back to what I said before about designating who you would want as guardian of your minor children, if let's say both mom and dad passed away. Special needs beneficiaries. I know that there was a webinar that had been done previously on disability law. So again, I'm not going to delve into that because you could probably I could spend another couple hours, on special needs beneficiaries. But to give you a quick synopsis on that, if you have a beneficiary that is receiving SSI and is getting Medicaid through SSI because he or she is disabled, one of the requirements to keep with SSI is that they have resources. In other words, any property that is in their name, that value of the property has to be under $2,000. Otherwise, all those benefits get cut off. So a lot of times when we have disabled beneficiaries in place, we have to build in trusts, special types of trusts for these beneficiaries to basically have their monies managed for them by their parent, by their loved one, by a brother or sister, for their benefit, to allow them to stay on SSI and Medicaid, while also simultaneously having whatever share they would have gotten, placed into trust, and then the trust be managed for him or her. And then the final item, and something that's is not very typical, but something that you would want a will in place for, is if you have specific funeral instructions and wish to designate somebody outside of your executor of your estate or trustee of the trust or guardian of your children as a funeral representative. The state of New Jersey allows you to designate whomever you want as your funeral representative. 95 times out of 100, it's the person that is administering the estate, but you could change that if you really wanted to. And you could also, if you want to leave specific funeral instructions that maybe you haven't, memorialized in anything in anywhere else. So, for example, if you want to be cremated, then you can you would put that into your will. If you wanted to do some type of crazy type of funeral, let's say you wanted to have a Viking style funeral. Not saying you would, but and you could theoretically put that in your will, and it's a request that ultimately your funeral representative would be bound by. So next slide for me, please, Pam.
Sure. I just wanted to add that since you touched on special needs beneficiaries, that webinar that we did back, I guess it was in the fall, is available on our alumni website. So if that speaks to anyone specifically, they can find that recording on our website.
Thank you, Pam. And that was my recollection as well. So I just wanted to, that's why I wanted to bring it up, because it is a very complicated and involved process, and a lot of topics to talk about there. So, but putting that to the side, I'm going to talk briefly too about trusts. One of the things you can build within a will, or you could create on the side for somebody is a trust. And a trust basically is a legal entity that owns real estate, that owns bank accounts, that owns any type of liquid assets, that and is managed by a trustee. Now, a lot of times, one of the things I had touched on earlier is minor trusts. A lot of times those are created for beneficiaries that are under 21, under 25. You could set that age wherever you would want it to go. And obviously too, the special needs trusts are created for those that have disabilities. Now, there are plenty of other trusts that are out there, and I kind of give a very basic list, on here of trusts that can be created either within a will or outside of a will. Disclaimer trusts are basically trusts that are created that basically say that if I pass away, my spouse doesn't want any of these assets, disclaims all the assets in the estate, that everything is placed into trust for him or her, and the trust is managed by that person. And that's usually done sometimes if you want to avoid the estate tax. Not very common in cases. And New Jersey no longer has an estate tax, so it's not a very common provision. There's life insurance trusts that are basically created for people that own a life insurance policy and then name as beneficiary this trust that is created. And you'll see a lot of this in property settlement agreements. So if a couple gets divorced, and one of the things that they agree to, if there's minor children, is that if one of them passes away, then life insurance benefits are placed into a trust that is managed by the other spouse, by the surviving spouse, ex-spouse, and those monies in there are managed either for the children, or it could be managed for the ex-spouse too, depending on if him or her is disabled for any reason. So life insurance trusts, you'll find those that are that's out there, and it's also a way for people to be able to manage life insurance proceeds for beneficiaries rather than having them get the benefits outright. Have them placed into a trust for the benefit of the beneficiary. Two other types of trusts I want to mention are revocable trusts and irrevocable trusts. The difference is within the name, whether or not you can collapse and revoke the trust, or whether you will not be able to do that. Now, a revocable trust is trust that owns assets and can be collapsed at any time by the person who puts the assets into the trust, any type of grantor. So a lot of times what we do is we set up revocable trusts for people if, let's say, they own real estate outside of the state that they reside in. So if let's say we have a situation where Pennsylvania, someone lives in Pennsylvania and owns a piece of property down the shore, Wildwood, Atlantic City, Point Pleasant, wherever, then what the person can do is create a trust. It could be a Pennsylvania trust, and then have that trust own the piece of property in New Jersey. And the reason for that is, if, let's say, the person passes away, okay, and you need to take that piece of property that was in that person's name and move it into the names of the beneficiaries. If it's in the name of the estate, in order for you to be able to obtain title to that property in such a way that allows you to move that property from the name of the estate into the names of the beneficiaries, you have to do what's known as ancillary probate. So in the situation I gave before, if, let's say, you own a piece of property in New Jersey, you live in Pennsylvania, and you die a resident of Pennsylvania, and your will is probated in Pennsylvania, then you would have to contact a New Jersey estate attorney to basically take the proceedings that were done in Pennsylvania to appoint the executor of the estate, and then be able to get that executor recognized in the state of New Jersey where the piece of property was owned, and then from there, once you get that person recognized, then that person then has the legal authority in New Jersey to move that investment property from the name of the estate into the person into the names of the beneficiaries. Now, that's a lot of, again, going back to saving the beneficiaries time and money to have to go through that process. The way to avoid all of that is to set up a trust for that person and basically put that real estate into trust for the person. And once you do that, you can then, make sure that you avoid ancillary probate. Okay. Once the person dies, you will have provisions in the trust that says when the person that owned the property, in this case called the grantor, when the grantor dies, I want the piece of property, I want the assets in this trust, I should say, moved into the name of X, Y, and Z beneficiaries. Okay, so that's a situation where you would want to do this type of trust. Now, contrast that with an irrevocable trust. And an irrevocable trust, you put the assets in, and once the assets go into the trust, you cannot get rid of the trust. You cannot collapse the trust within reason. There are exceptions to that. Like with anything in the law, if you take nothing else out of this, with anything in the law, there's always exceptions. But to keep things as simple as possible, and we're going to put that to the side for now. An irrevocable trust, you put your assets into, and it's managed by a trustee of some sort, and that person allows you to, or operates, and if it's real estate, if it's bank accounts, manages the assets according to the terms of the trust. Now, a lot of times we do that, for elderly clients when we're looking to do, asset protection and all, and for Medicaid purposes, that's one of the things that we talk about, is moving the property out of that person's name in order for them to be able to get them in a position where they could, go into a nursing home and be able to qualify for Medicaid. So Now, that's an example of where you would use in irrevocable trust. Now, Medicaid asset protection, I could probably do a whole nother webinar on that. So I don't want to, I don't want to burden you with, with all that, information. But certainly that is a possibility. So next slide, please. And by the way, I'm seeing all of your questions. Thank you for all the questions. We will be answering everything, towards the end. I know, and I know Pam will, if you want to comment on it, she runs the Q&A portion at the end. So.
Yeah, Steve, I'm glad you mentioned that. I did just want to give you a gentle reminder of the time because you probably do not have it in front of you.
Okay.
So the slides. We are approaching 1:45, and I do want to leave time for those questions.
Yes,
So,
absolutely. I'm sorry.
Nope, no problem at all. I just want to give you a reminder if you don't have the clock in front of you.
Yeah, unfortunately, I don't have the clock I can look at it here, so and I can't, couldn't look at my watch. So I can talk about this all day. So the estate tax, as I mentioned, New Jersey estate tax was eliminated in 2018. New Jersey does have an inheritance tax. I'm not going to read this for you. You can look at this, on your own time. But basically, the assets, if anything goes outside of a child, a parent, grandparent, domestic partner, husband, wife, partner, then it will be taxed. And so another reason why you want to do estate planning and potentially move assets into trusts or what have you is to be able to avoid this, the inheritance tax, especially if it's going to somebody like a brother or sister or another beneficiary outside of that. So next slide for me, please, Pam. So a couple of the biggest mistakes in estate planning that you can make are making sure that the will isn't properly executed. One of the things that I have to deal with on a regular basis with estate administrations are people who do not execute a will properly, or in a situation where they don't tell their beneficiaries where the original will is. You need that in order for you to be able to probate the will. Moreover, you also need to have a will that is witnessed by two neutral witnesses, and the signature needs to be notarized by a notary public in order for that will to be recognized by the surrogate. And so a lot of times that will cause a lot of money being spent on unnecessary litigation that needs to be filed with the courts to basically ask them to probate a copy of the will or probate a will that is not conforming to these formalities. So very critical if you put that in place that you have all that taken care of. The biggest mistake that you can make, though, is making sure that your probate and non-probate asset beneficiaries are in sync. So when I say probate assets, I think of any assets that are not being controlled by a beneficiary or an ownership or a joint designation. So for example, assets that, going back to my example before, assets where a husband and wife own the piece of property, and then husband dies and wife is the sole owner, and she passes away, that would be considered a probate asset. Contrast that with an asset like an IRA that has a beneficiary listed on there. That person who gets the money would be considered a beneficiary, and it would be an asset that passes outside of the will. So making sure that your beneficiaries line up to what your ultimate estate plan is, then is critical, because the last thing you want to do is to have an asset go to somebody that you don't want it to go to. And I kind of put in some specific recommendations of things that you could do with your current assets. So for example, if let's say you wanted to get to the TCNJ, foundation, you have to write in the will that I leave my property to the College of New Jersey Foundation charity instead of the College of New Jersey, because it might be considered a bequest that the executor may not know what to do with. And So that's something that, you know, you'd have to correct it. Next slide for me, please, Pam. And then some other things are naming two people as co-executors. It's not a big deal, but it's something I never recommend, because ultimately you want one person in place to be able to manage the estate. I just had somebody come in where there were two co-executors for an estate, and the one executor had no idea what the other executor was doing. And there was a piece of property that was sitting in the name of the estate for almost 25 years, and they didn't know what to do with it. And she didn't know what to do with it because her brother, who was the co-executor, had not kept her up to date on everything. So that just creates a havoc. You have one executor who manages everything, and you know, that's it. Listing out your personal property in a will is something that also can make for some headaches, especially when you have an insolvent estate, an estate that doesn't have enough assets to pay all its creditors, because ultimately you have to pay those before the beneficiaries get anything. So in that situation that I described on the screen, the heirs had to liquidate the decedent's trains, heirlooms, paintings, things like that, and get the money for that to be able to pay the creditors, because the creditors said, well, these are assets of the estate, you know, but what do we, why can't you liquidate them? So naming kids as beneficiaries, if you think nothing else from this, make sure that your minor children are not getting everything outright. Disabled beneficiaries, naming them directly is something that you don't want to do for reasons I've explained earlier. And then moving to another state, not changing your will, you got to make sure that your will is in compliance with those states' requirements. So, you know, be on the lookout for that. Next slide for me, please. And so finally, I'll talk about this very briefly. Power of attorney for before you pass away, as I talked about earlier in terms of managing assets, you know, making sure that your finances are being properly taken care of while you're in a nursing home or becoming incapacitated becomes so important. And a power of attorney document allows your agent to be able to manage those assets on behalf of your on behalf of the person who's still alive. So you know, you can limit or grant powers to your agent. You can make that document effective immediately. You can make it effective upon disability. It does terminate on death. So I've had many people say, well, in the state administration, why can't I just use my power of attorney? Well, it's because it's no longer it's null and void, I should say, and it doesn't do anything for you at that point. Again, if you don't have a power of attorney in place, you'll have to ask the court for a guardian, and that's a whole process to basically vet you to make sure that you are a guardian material. It requires doctor certifications, thousands of fees, yearly reports and accountings to the surrogate, and it becomes a hassle and a nightmare and something that you don't want to deal with. So definitely got to have a power of attorney in place. And next slide for me. Healthcare directive is kind of like your health power of attorney. You appoint a healthcare representative to be able to make medical decisions on your behalf, and you could put into place and give your family the peace of mind that they need for what, you know, when you want them to pull the plug, if you want them to be able to give anatomical gifts, organ donations, how to keep someone, you know, whether or not they need to keep someone alive. It creates that peace of mind for the family to know what you would like. So next slide for me. So I leave you with this statement. An initial investment now to create your estate plan saves your family money and aggravation in the future. And if you've ever seen the movie Knives Out, where basically you've got a family at each other's throats trying to figure out what to do with the father's estate, and you know who killed the father and what ultimately happens to his estate, then you see the actors going at the at the beneficiary saying, I want to ruin the movie for you, because it ended up that the money did not stay in the family. if you want to try to avoid that, situation, make sure that you put the time and the energy in now to make sure that your estate plan conforms to what you want. And with that, we'll open the floor to questions.
Steve, thank you very much. You covered a lot of really great information for us. And when I say a lot, I mean, there's a lot to be said on it. So thank you for taking the time and putting together a great presentation.
I appreciate it. I'm sorry I went over a little bit. I thought I had more time than I
There's a lot
did.
to cover. And we still have time, so no problem at all. And let's see, I'll scroll back up, starting with our Q&A.
Mhm.
All right, so our first question is there an inexpensive way to make a will online?
There is, you can use, I know there are some alternatives that are out there, LegalZoom, what have you. I'm sure there are templates online. Keep in mind, though, that you got to make sure that everything conforms to the law, because if you don't, you have a situation like I explained earlier about trying to probate something that isn't, that doesn't meet the four corners of the law and becomes an issue in terms of probating. So, but yes, there are alternatives that are out there.
Okay, great, thank you. If a child is 18, does the New Jersey default beneficiary rule apply to them?
So in terms of anybody that is 18, yes, the default intestacy distribution rules apply no matter your age. The only thing the New Jersey law cares about is the blood relationship from the decedent to the person who would otherwise be entitled to the assets. So very simply, the answer is yes.
All right, let's see here. From Judy, we have, can you change a deed to include husband, wife, and child?
Absolutely. You can change your deed to whomever you want, but keep in the back of your mind that whoever is the legal owner of the property is also responsible for the expenses of the property. So if husband and wife are the ones paying the expenses and they start defaulting on them and there's a foreclosure action or what have you, then then the child is going to also be implicated in that. So just something to keep in the back of your mind. The simple answer is yes. You can structure your real estate however you want.
All right. All right. You can be you can be appointed as an executor if you have no children or anyone else. I think someone was answering someone else's question on that one. All right.
Whoever you designate as executor, you can appoint. Whoever you want.
If uncle has will and is not found at time of death,
Mhm.
and it's not found at the time of death, can nieces and nephews apply for division of the estate, or does it go solely to a sister? Do you follow that one?
Yeah, I hear what you're saying there. The uncle, so in that situation, if there is a will, first off, if let's say the nieces and nephews don't find the will and they want to get someone appointed as the representative of the estate, you could do that if you really wanted to. And then there could be a time period after that, if you do find the will, that you offer that will to, up for probate. There is a duty to have to, provide that will for probate purposes. But yes, it is possible for nieces and nephews to start the administration of the estate and then probate the will after that.
Okay.
I hope that answers the question.
All right, I'm switching to some of the questions that we've received by email, and thank you for submitting them ahead of time. That's always great. Is it necessary to contact the preparing attorney when fulfilling a will, or if you have the document, will that suffice?
If you have the original document, then that is all that is sufficient to get the ball rolling. I've dealt with many estate administrations with wills that were done outside of our firm, and that's very common. People hire us, for that purpose. It doesn't have to be. You can use that attorney that did the will. It's if that attorney wants to take on the case, it's up to you how you want to handle it.
Okay, thank you for that.
Any
Okay,
questions?
who Who came to be appointed as an executor if you have no children or anyone else capable? Excuse me for that.
You can, a lot of those situations, if people don't have a legal representative that they want, they don't have a child, they don't have a friend, sometimes they can appoint whoever. If, let's say, they want an attorney, there have been times where we've been named, the firm has been named as an alternate, as alternate executor situation to administer the estate. So it is possible to, you can name a lawyer, you can name whomever you want. You can name, literally, you can name whomever you want to be able to administer your estate. But sometimes, if nothing else, we'll step in as an executor of the estate and administer the estate.
I'm going to jump in and say, if you're going to name an organization to be executive of your will, make sure they're able to be that executor, because at the college, we cannot be executor of anyone's estate because of state law. So we wouldn't, well, we would do it formally, but we're prohibited by state law. So if you have an organization do it, make sure you talk to them ahead of time.
Definitely. Let them know ahead of time. There are trust companies that are out there too, by the way, that can administer the estates as well. So, that is a possibility too.
All right, we have a question from John. Is there a timeline where wills or documents should be updated, i.e. every 5 years or so? Or if there are no family changes, should the original document be okay?
That's a good question by John. And honestly, I'm going to give the lawyer's answer on this one. It depends. I mean, because you can have family change. If there's family changes, you want to add somebody in there, that's fine. If you want to take somebody out of your will, then that's a good time to do a new will. If you come into some money, into some assets, and don't know what to do with them and want to change your estate plan there, then you do another will. So it's a hard question, to answer. If the family structure hasn't changed and you want to keep it as is, then that's fine. I mean, I've got, it depends. It really does depend.
Okay. And this, I believe you did answer in the presentation, but I do want to make sure that I acknowledge the question. What is a better way to pass real estate properties to children, especially when the properties are in another state? Setting up a trust or instead of a will, et cetera?
Well, if in terms of the, I'm trying to see if I am understanding the question. If everything is going in, if theoretically, if you want property to go to the children, if they're minors, then you would want it to go into trust to be managed by him or her, because the last thing you want is the children to have to try to manage the real estate and they don't know what they're doing. Now, if you've got adult children and you want them to get the property outright, then you don't have to do any of that. But it's, it depends. Again, it depends. And the reason why I mentioned the revocable trust thing is for property that's out of state. If you want to use that in lieu of ancillary probate and going through that process, it just makes things easier, from a financial standpoint, to just be able to have the trust on it, and then the trust will determine what to do with that property.
Great. This may be a personal opinion, but we have a question as to where the best place to store estate documents is.
You're welcome. Okay, you're welcome. Where's the best place to store estate documents? Well, again, I'm gonna kind of go and say it depends. We have clients that have their estate planning documents in our safe on, in this office. We have clients who put things in a special drawer in their house and then tell their kids, okay, this is where all my stuff is in case something happens, kind of like break the ceiling, in case of an emergency kind of thing. You can put things in a safety deposit box. One thing though about safety deposit boxes, make sure your kids do have access to that. There are ways to get the original wills out of a safety deposit box. The surrogate can authorize the bank to open up the deposit box and pull out the original will. But again, it just creates more complications, more hassle. So, if you do the safety deposit box, make sure your executor knows where the keys are.
All right, and Steve, we are at 2:02, so I'll ask one more question. I'll end with this. Is it necessary to have the POD feature on bank accounts, even if there's a will in place?
The answer to that question is no. I mean, the reason why you do the POD beneficiary is if you want to, if you don't want to probate your will, and you want that asset to go to your beneficiaries. Remember what I said earlier, beneficiaries trump the will. So if you have a POD beneficiary in place, whoever's the POD beneficiary is going to get that asset. The will is not going to control that. So if, let's say, you just own a bunch of bank accounts, excuse me, and they have POD beneficiaries on them, then you don't need to probate your will because everything will just go to the payable on death beneficiary. So it is possible to do that, and then it avoids the process of probate, you know, and the money involved with, you know, with doing that. So
I know
that's
there
why
was-
I'm sorry, Spence. I was just going to say.
I
that's
know
why
there was one
beneficiary is
question-
very important.
And I don't know whether you answered it or we were asked it. Does a will supersede a property trust? For example, a house is in a trust with different percentages than the will stipulates.
The trust, if the house is owned by the trust document will supersede whatever the will says, because the trust is the one that owns it. So yes, the trust would trump the will in this case.
Thank you.
Now, if the trust doesn't say anything, theoretically, you can make an argument that the will is, you know, would trump that, but that's, you know, now we're kind of going far down to the weeds that we need.
I think we're out of time. I want to thank you, Steve, especially for this great presentation. I thank Pam for doing all the technical stuff. That's great. And I want to thank everybody who joined us today. I hope you found it informative. It will be on the website later. And what else did I miss, Pam?
Yeah, it'll be on our TCNJ alumni webpage, along with all of our future industry insiders that we have coming up all spring. So keep checking that. And yeah, I just want to echo Jim in thanking you, Steve, for joining us and giving some great insight and some awesome answers to a lot of questions. I think a lot of our alumni took a great deal from this. So thank you very much.
Right. I'm glad they were able to. I thank everybody for coming. And you'll make the PowerPoint available, right, Pam?
Yep. If you're okay with it, I will. And your
That's
contact
fine.
information is in there. So feel free to reach out to Steve if you need anything further.
Happy to hear from my TCNJ alumni. Happy to hear from my fellow Lions.
Thanks, everyone.
And my Lions colors, you know, I'm a Lion here.
Thank you so much, everybody.
All right. Take care, everybody. Have a great day.
All right, Steve, thanks again. Have a great rest of your week, and I'll be in touch.
Yes, thanks for having me, Pam. I really appreciate it.
Anytime, anytime. Thanks.